My name is Richard Goemann. I'm the Director of Defender Legal Services for the National Legal Aid and Defender Association. And I can't tell you how honored and privileged I am to be here. And I want to really just thank you all for being here and spending your day and tomorrow doing this work. This is hard work. This is difficult stuff. People have been wrestling with how to provide equal justice in our communities for a very long time. And that's what this work is. This is the work of equal justice. It's a fundamental American ideal, and we've yet to achieve it throughout our communities. And it's hard work. It's been something that's been talked about and wrestled with for thousands of years, in fact. To my mind, one of the earliest quotes that describes equal justice and the need for it is something you might be familiar with. Justice, justice, you shall pursue. Justice, justice. Justice for rich, justice for poor. Justice for insiders, justice for outsiders. It's equal justice that is being talked about in that wonderful quote. And it is really an important job, and I'm really thrilled to have been able to spend the day learning about your struggles with equal justice, and I'm really excited about tomorrow, where we'll really roll up our hands. Hopefully, our hands will stay where they are. Well, we'll roll up our sleeves, leave our hands at the end of our arms, because that's the most effective way to get work done. And actually start getting some work done, working on the plans that will eventually become your vision of equal justice for your communities. As I was sitting here listening to all the stories that I heard during the day about the different systems that you're working with and kind of the place where you are and the place where you want to be, the image of a bridge came to mind. A bridge is a wonderful kind of symbol because, of course, it starts in one place, point A, and it goes to point B. And while you're moving from point A to point B, you're somewhere in between. You're transitioning. And I get the sense that what brought you to this room here today, and what you might have chose to come, somebody might have told you to come, whatever it was, however you got here, somebody wants to get your justice system from point A to point B. You want to traverse this bridge to get from one place to the other. And that to me is a very kind of powerful way of thinking about the journey of equal justice that everyone here is on and that your communities are on. A bridge is also, to me, a good image to think about the criminal justice system itself. When you think about a community building a bridge, I know it might not be intuitively obvious how that's related to a criminal justice system, but when you think about it, a bridge is something that, number one, is very expensive, as is your criminal justice system. It is a fulfillment of a major governmental responsibility. Transportation, roads, bridges, that's something that government does. Criminal justice, public defense, those are important governmental responsibilities. And they can both hurt people if they're done wrong. They can both be very damaging to people if they're done wrong. So if a bridge is done in the cheapest, most expedited fashion possible, without sufficient planning, without looking at standards to determine how it should be done properly, eventually people can get hurt. Likewise, if you have a criminal justice system that is not sufficiently thought out, and of course that's what we're here about, right? We're doing that kind of work here. But if it's not sufficiently thought out, if it's not planned, if you're not referring to standards for safety, for fairness, then people can get hurt. And I'm not just talking about the folks that I primarily work with, and that's the public defense community and their clients, but I'm also talking about the witnesses, the victims, people who are expecting fairness and justice from their system, they can get hurt as well. They also both impact large segments of the population. I mean, obviously with a bridge, huge numbers of people are going back and forth. In the criminal justice system, again, you have, it's not just the defendants that are beneficiaries of a fair and high-quality criminal justice system. The community benefits as a whole. You have the witnesses and the victims, people who are directly impacted, but also it is a bond that the community as a whole needs to have faith in. And when they do have faith in, it strengthens the bonds of the community. Folks are more willing to be part of that system, to work with police, work with prosecutors, work with defense attorneys to make sure that there's fairness and justice at the end. So there's a very wide web that's cast by the criminal justice system that really forms bonds within the community. So that's why I say it's something that if we just think about it as the prosecutor and the defendant, or the prosecutor and the defense attorney, that really doesn't capture how wide the effect of your justice system can be. The one difference is that although they both fulfill major responsibilities for the government, building a bridge is discretionary. Having a criminal justice system and a public defense system is not. Those are constitutional responsibilities that government has. So in that one sense, there is a difference. But the fact of the matter is that they're both huge responsibilities, and they can both really lead to people getting hurt if they're done wrong. The bridge, though, the bridge is built, of course, on a platform that has various pillars. And this will be the last the last try at this analogy, and then I'll move on. The pillars are the various players that we've been talking about: the prosecutor, the judge, the public defender, the indigent defense system. Also, of course, probation and parole, the sheriff's office and the jail, the police. All of those are holding up that bridge. And they all have to be strong to have a safe bridge. They all have to be fairly even. They have to be able to accept equal amounts of stress. And we've kind of talked a little about that today in terms of equity and parity amongst the different systems. And we'll talk about that a little more in a moment. But you can't have different pillars that crumble and some that stand strong and some are 10 feet high and others are 3 feet high. You'll never get a working bridge that way. But if they all are strong, if they all are even, then the bridge is strong, it's safe, it lasts a long time. And I think it's important to keep that kind of image in mind, because when you build a bridge, really the first thing you think about are the standards that you're going to use to build it. You're not going to simply contract with the cheapest, the first person that comes along and says, I'll do it. First, you're going to figure out the quality that you need. You're going to look to building standards, codes, national standards as how bridges ought to be built. You're going to require whoever bids on that bridge to meet those standards. And then you will take the one that can do it most efficiently, the one that can do it the fastest, which is important. We want it done quickly. You're going to want the one that's not going to waste government money, absolutely. But they all have to meet that standard first. And again, that is a very good way to think about criminal justice and the pillars that underlie it. For me, the examples that I give here and what I'm going to be talking about is primarily from the public defense perspective, because that's where I come out of. But I think the ideas are the same for each of the pillars that underlie the criminal justice system. They all have to be working properly for the criminal justice system to work and for us to get justice, for the community to get justice. So how does that go back to the case management and the case flow that we've been talking about this afternoon? Well, you'll see in your materials that one of the major steps when looking at differentiated case management is the need to figure out how much time is required for each step of the way. And it's just in your materials here, the kind of the big book we've got here, there's something called a simple guide to differentiated case management. And in there it says that one of the key features, you don't have to look now, you'll look later, and it'll be there, trust me. It says the categorization of cases into groups according to complexity and priority factors. So how much time does each case normally take, on average, this kind of case? And what I'd like to suggest to you is that that question should not be answered until you've figured out what each of those pillars needs to function properly. If the public defense system, and again, I think this applies to others as well, but if the public defense system is not functioning properly in your community, then it's very hard to say how much time a case should take in order to properly be litigated from beginning to end. So if you have, for example, let me just say, I'm not going to go through all of these slides. They're primarily there for you to take back and take a look at later on. They're mainly guides to some of the standards and materials that are in your book. But if public defense attorneys do not have access, for example, to investigators, and there are many, many communities across the country where the public defense system don't use investigators. Either the public defender office itself doesn't have investigators on staff, or you have an assigned counsel system where courts don't routinely provide investigators for whatever reasons. Historically, that's not been a part of the practice. But national standards require that defense counsel properly investigate their cases. Well, if they're not doing that, then any estimate of the time that they give, when they're asked the question, how much time does it take to do this kind of case, to do a larceny case or a burglary case or a rape or robbery case, the amount of time that should be dedicated to investigating that case isn't going to be in there. And in essence, what you would be doing is taking the current practice at whatever level it is and embedding it or institutionalizing it into the case management system. And what I'm here to suggest is that one of the questions you need to ask before that happens is you need to take a step back and say, what does our system need in order to properly function? And what you'll see in the materials are various standards, and I should actually, before I go on with that, thank the judge a little earlier. That was, who was the judge? Judge Waldrop. Sorry, Judge Waldrop, who talked about the ABA 10 principles of a public defense delivery system. He also talked about the National Legal Aid and Defender Association and the National Juvenile Defender Center's 10 core principles for quality representation of delinquency cases. Those are national standards that you can look to in determining whether your system, your public defense system, is functioning the way you want it to. And those are all in the back of this book, the large resource book that you have there. The ABA 10 principles, as Judge Wardrop noted, those principles, and this is what the principles say, constitute the fundamental criteria necessary to design a system that provides effective, efficient, high-quality, ethical, conflict-free representation for criminal defendants who are unable to afford an attorney. And really, as I, going back to the beginning, that's what equal justice requires, right? We want effective, efficient representation, but we want that efficient, effective representation to satisfy the standards of equal justice that our community has a right to and deserves. Similarly, if you go all the way back to the back of your materials, there are the 10 core principles for juvenile systems. And I heard earlier when Wesley was giving his presentation about the new plan submission system, thank you, that you need to put in 2 programs, right? You need to put in a plan for adult and a plan for juveniles. And so there are different sets of standards. They overlap, and there's a lot of similar features to them, but there is a recognition nationally that juvenile delinquency is different in some ways and requires a different set of principles. And those principles provide criteria by which a public defense delivery system may fully implement the holding of In re Gault, the Supreme Court case, the United States Supreme Court case, that said that the status of being a juvenile does not justify a kangaroo court, that juveniles have the same, or at least very similar, due process rights to fairness that adults have. So by referencing these kinds of standards, you can be assured that your public defense system has all of the resources that are necessary and is taking all of the steps in the process that are necessary in order to provide competent legal services. And that, again, that's what you need, along with, I should say this again, along with the prosecutors and judges having all the resources that they need to do their job. I've talked with many, many prosecutors across the country, and they often talk about the same sort of things that the public defenders often talk about, and that they often are very dissatisfied with the way that they practice. They have very high caseloads too. They don't get to spend time with the witnesses in their cases. They don't get to spend time with the complainants in their cases. They're often, they're just grabbing, when they get the police report, they're just grabbing it and putting the witness up on the stand. That's not the way they'd like to practice either. So there's a lot of common bond here that I think can be made, and judges often are dissatisfied with just kind of pushing dockets and moving dockets and the pressure that they feel to simply get through a number of cases within a certain time period. The differentiated case management system, I think, can be a wonderful tool to alleviate those kinds of pressures, or to at least make them somewhat more bearable and to make the system work better. But they have to, the differentiated case management system needs to be built on a foundation where all of the players, in essence, are working efficiently and have all the resources they need to do the job. And I was very, and I've heard a number of times during the course of the day, and certainly from Judge Parnham, the idea that indeed at a leadership level, all of the players need to come together. This is not exclusively something that's going to help defendants, the accused. It's not exclusively something that's going to help victims and witnesses. It's not exclusively something that's going to help the taxpayers and the county coffers. But it can have benefits for all of those players. But please look first to see what does my system need in order for each of the parties to be functioning at the standards that they need to. Then we can talk about how much time is it going to take to do each of the to go from beginning to end in a misdemeanor case, in a felony case, but not until then. I did want to mention basically kind of four of the primary or most important standards that are a great place to start. And that is independence, having standards, having adequate funding, and having appropriate workloads. These standards, as I pointed out, there's 10 juvenile standards, there's 10 ABA principles, and there are a lot of other standards. But These four are the places to really start the work. A public defense system that lacks independence has real difficulties getting a handle on its caseload. It has real difficulties finding the resources that it needs to do the job right. Going back to the investigator, if you have a public defender who cannot independently judge the need for an investigator because they are too beholden to a judge or to the executive of their government, then they're not in a place where they can make decisions based solely on the needs of the client. Going back to Powell versus Alabama, U.S. Supreme Court case, how can a judge whose functions are purely judicial effectively discharge the obligations of counsel for the accused? How can a judge be in the position of making decisions about what kind of resources the attorney needs in order to do their job properly? And here's something from some ABA standards, and the second sentence there: the plan and the lawyers serving under the plan, and that's what you're working on, right? These plans should be free from political influence and should be subject to judicial supervision only in the same manner and to the same extent as lawyers in private practice. So a public defender or an assigned counsel attorney or a contract attorney should be beholden to a judge or to the executive branch only to the same extent that a private attorney would be. And I think Judge Waldrop mentioned that there are mechanisms for creating this kind of independence within a county system, talking about nonpartisan boards where the executive, the legislative, the county council, the bar, local bar, can all get together and form a oversight board that then gives the public defender the independence they need to make decisions based solely on the needs of their client. And then you'll see in the materials, again, you don't go through them now, I'm not going to read them. There are recommendations on how to go about doing this from recent reports. A lot of this is in your materials. Standards is the next thing. We talked about the need to look to national standards. Standards are key. This is from the Justice Department, from a report from 2000, the United States Justice Department. And if you read about what they're talking about, standards are the key to uniform quality in all essential government functions. Building a bridge, building a road, building a building, a government building, right? You look to standards all the time. Indigent defense is really no different. In the indigent defense area, uniform application of standards is an important means of limiting arbitrary disparities. So here they're talking about states and nationally, and the standards are that there needs to be uniformity, some uniformity of quality throughout a state, and hopefully eventually nationally that there's some uniform quality. It doesn't mean everyone has to do it the same way, but the standards that are set for competent representation should be the same across a state or across the nation. But you look to the standards in order to help you achieve that. How you implement the standards and what's best for the particular community or the particular state, that can be different, but you reach the same standards. And again, there are recommendations in there from recent reports on how to do that, how to think about that. Funding, I mean, that obviously has been an issue that's either been talked about explicitly or implicitly throughout the day, that funding is always a concern. And it is. It's a reality that this is a matter of taxpayer money, and that funding is always going to be an issue. But again, if the standards come first, if you're thinking of safety, if you're thinking of what's best for the community as a whole, if you're thinking about the need for equal justice, then that comes first, and then you figure out how best to fund it to make sure that taxpayers' money is used wisely and not wasted. Once you have the caseload, once you have adequate funding you have independence. Caseloads need to be addressed. I know I'm moving very quickly, but I'm very aware that we're getting towards the end of the day. Caseloads are one of the main symptoms of systems in crisis across the country. Kathy Grasso mentioned first thing this morning that the Attorney General of the United States has termed indigent defense in our country in a crisis. And the caseload issue is one of the symptoms that often we see because it's easy to track. You see public defense offices with hundreds and hundreds of cases. And we could go one step further. How do we know that attorneys are working through all the steps that should be worked through properly in a case? And of course, part of that has to do with training, but there are even guidelines for that, for what it takes to properly work through a case. And the fact of the matter is, some of you are lawyers, many of you are not, but the lawyers amongst us will, I think, agree with me that law school does not teach you how to try cases. That's not where you learn it. You learn it when you go out into the community, when you go out into your law firm, or you hang out a shingle, or into your public defense system, or your prosecutor's office. That's where you learn to try cases. And if folks there don't have the resources to do the job properly, they're doing the best they can. They've been working this way for many, many years, and they might not be able to even train properly on it. So we look to, here's a book that each jurisdiction, and I brought enough for each jurisdiction to go home with one for you to take a look at. These are performance guidelines for criminal defense representation. And you can look through here, and it lays out, it's basically a long checklist of all the things that again, I'm talking about defense counsel should at least be thinking about in every case. They might not do every single step. Not every case requires it. But they need to have the time and the resources to properly think about it and to know that if they do need it in this particular case, that there's the resources to be able to provide it. Because if they know, if they know that they're not going to get an expert, then they stop thinking about even whether experts would be helpful here. And they just keep moving down, and they're not really thinking through each step. And a lot of that, it's not a matter of lawyers just doing bad jobs. Everyone's doing the best they can, and many are doing heroic jobs and wonderful jobs. But we're not talking about the exceptions. We're not talking about, I often hear judges say, oh, I have some great lawyers who practice in front of me, and I'm sure many of them do. But what we're trying to do is create a system where everybody is getting the representation that they have a right to and that they deserve. And that our community, I think our communities want them to have. We all want to provide equal justice in our communities. I started off, and let me tell you that when you start looking at the standards, I think you'll see that this is really hard work. It's not something that you can just jump to. And Judge Parnham, also talked about that there are a lot of steps that you need to go through here to do this right. We're here as a resource, the National Legal Aid and Defender Association. You heard about OJJDP as a resource, the National Juvenile Defender Center. There are other resources in the ABA, of course, National Center for State Courts. A lot of people who want to help raise all of the boats. I'll go back to my bridge analogy one more time. Another old saying that I've heard is that the entire world is a narrow bridge, and the most important thing is not to be afraid. Creating equal justice. That's our world here. Creating equal justice. It is a narrow bridge. It's a lot of work, and it's sometimes frightening to get across it. But the most important thing in keeping your sights high, that equal justice is a possibility, and it will be a reality in our community, is to not be afraid. So I really look forward to working with you tomorrow, and and I'm happy to, I'm going to be here tonight, I'll be here tomorrow, happy to talk with folks about it, take questions. I don't know if we have, I guess we're getting kind of tight here. I will stay here afterwards if people want to talk a little more about this. I'm happy to stay around and just chat for a bit. But I really am excited about this opportunity to join with you on this journey for all of us to creating equal justice for our communities. Thank you.